Yes, welcome to the No State Project Day of September. Is it 28? Yeah, 28th day of September 2019, live from the fortified compound in Mesa, Arizona. Let's see. I am screwing things up already, but I'm going to try to do this without having to go and show everybody my crack again. Appreciate everyone tuning in. Everyone start filing in. I wish that it was set up that people would get notifications right when we started. And a lot of people are not getting notifications. I don't know what to do about that. I don't know if there is anything that can be done about that. I guess it's just something we have to deal with. It's just an issue with what do you call that there, YouTube. But welcome to the No State Project for the 28th of September. You want to join me on the big broadcast today, you may do so by calling 218-632-9399, 218-632-9399. I should have had that up in the so maybe if somebody else can put the caller number inside the in the chat so to help people with that. But it is 218-632-9399. The passcode is 2020 with the pound sign or the hashtag, depending on your age. And I want to thank everyone for their continued support of the show. If you want to be able to do that, it is much appreciated. MarkStevens.sells.com. That's SELZ, sells.com, markstevens.sells.com, and also markstevens.net. And in markstevens.net, you can get you can't get Adventures of Legoland except as an ebook, because that's like 16 years ago. But Government Indicted is the newer one. It has a full model on how to effectively defend yourself and has been proven since its release because we've been able to replicate the success of what we did prior to that. And that is a really big thing if you can replicate the success. I know there's going to be a few people that say that there was never any success, that it's all coming down to reasons that they have to assume. But there is documented proof. So if you want to know for yourself, do the investigation. Don't worry about what people are saying on YouTube. Do your own investigation. MarkStevens.net on the success stories. There's documented proof from not just the United States, but Canada, Australia, New Zealand, and England. So you can check that out and do an investigation and come to a rational conclusion on your own. Does the evidence support the conclusion? And you'll see that it most certainly does. I also have, in addition to that, scripts available and motion templates. And yes, you can see at markstevens.net where the motion template has been granted. But as I want to go through here today, an argument's merit, is it just based on whether a judge has accepted it or not? Well, the thing is, as anybody could tell you, pretty much every legal argument that has ever been raised in court has been denied. So whether you're talking about Fifth Amendment, Fourth Amendment, First Amendment, every single legal argument has at some point in time been rejected. And so so you have to keep that in mind. Whether it has been accepted by a judge or not is not something that determines whether the argument is valid. The argument is valid on its own by the basic principles of logic. Is it based on facts? Is it logical? Does it follow? Does each proposition support the conclusion, or does it lead to a natural conclusion? The fact that it is rejected in court has no bearing on whether an argument is actually frivolous or not, or actually has no merit or not. You have to look to the actual argument itself. And there are a lot of arguments that are accepted in court. They're accepted every day. Does that mean that they're valid arguments? I would say absolutely not. Absolutely not. And I will talk about some of those cases. I have personally seen that in my own experience, in and out of court, whether it's administrative, where prosecutors, lawyers make frivolous arguments, and they're accepted all the time by the court. because it's not about the merits of the argument. It all really, when you're talking about taxes and drugs and you're talking about traffic court, the determining factor as to whether an argument is valid is who is making it. If it's being made by the government, doesn't matter if it's the stupidest thing the judge has ever heard. He's going to accept it. One of those things is that, like Tiffany Castillo, who's a prosecutor up in Concord, Massachusetts, or Kankakee. She argued that she can make a foundational claim, okay? And she did not need evidence. A foundational prosecution claim that set the relevance for the entire rest of her argument. She actually argued she was not required to have evidence for a foundational legal claim. Now, that is pretty much the standard definition of frivolous because it has absolutely no merit whatsoever, doesn't controvert any of the points that may be raised, and is certainly brought in bad faith. That is an actual example of a frivolous argument, about as frivolous as you can get. Saying that it's because it's not only that they have no evidence, and we have no, they admit that, but to go one step further and say that they don't need evidence. And yet, I've got a handful of critics that will pound the keyboard that I'm the criminal. I'm the criminal. I am the dangerous one. I was actually accused by somebody that I'm dangerous. I don't have a prison system. Unlike those co-government, everybody recognizes it is wrong if I was to force a perfect stranger to give me money, even if I was promising to do really good things with the money that I stole. That doesn't matter. The fact is, you're stealing, you're a crook. You're a crook. Those same people don't see how that ethical and moral standard applies to those co-government. And how the people will criticize and never examine whether or admit or even try to discuss whether that the system, the government, is actually a legitimate moral and ethical institution or organization. No, Marc's the criminal. Oh, okay. All right. There's no evidence to prove that, but they argue that anyway. But of course, that's what statists do. So I released the video yesterday, finally, of the anatomy of a frivolous argument. And I don't want anyone to think that the scope is limited to just taxes. It's not. Because the actual frivolous arguments, like I mentioned with Tiffany Castillo over there in Concord, Mass., it is the foundational legal claim being used against us by those co-government. And that foundational legal claim is the same whether it's the United States or Canada, Australia, England, doesn't matter. It's all the same thing. If you're physically in Alberta, Canada, the laws apply, and that is what gives them territorial and personal jurisdiction over you. And that is the basis of their subject matter jurisdiction, that you violated their code somehow. And there are those who want to argue, and I think this is a frivolous argument, they don't have to prove that. They don't have to prove it. Well, the only reason why they don't have to prove it is because they got a prison system and they've got a group of lawyers and bureaucrats that will not hold them to that particular rule. Oh, but if you and I dare, look, and you ask them, I asked them straight up, can I make a foundational legal defense and not have to prove it? No evidence whatsoever. Do I get to do that? See, and this is where the rubber meets the road. When you point out the contradiction, they want to be able to argue against us without proof that the literal foundation of their case, they don't need to prove it. But they're not going, they're not going to extend that to us. Not that I'm looking for that, because that's as dishonest as hell. So like I've said so many times, if making a foundational claim without evidence is okay for the prosecution, Why is it not okay for us? Because it is a corrupt criminal organization. You see what's playing out every day. Holy crap. At least, the thing is, we're used to having people, bureaucrats at the federal level, that they're smart enough to cover up their crimes. Nancy Pelosi with the conflict of interest, passing laws where her husband's business is involved. We know politicians do that. But now we're seeing it just brazen in your face corruption. It's not behind closed doors anymore. Nothing's going to happen, of course. Nothing's going to happen. You're just going to keep doing it. So the frivolous argument, the anatomy of a frivolous argument I went through in the video, is not just when it's not just in limited scope. You should be able to, you should apply that to every argument, especially, when they're accusing us of making a frivolous argument, which is just a standard, screech that these lawyers will do. I've even cornered bureaucrats thinking it's a frivolous argument. And you ask them, well, what part of it is invalid? What do you disagree with? That's why I say in the video, this is not about showing where the argument is illogical and that the facts are wrong. This is a sacred cow that we're going after, the foundation. And it's that challenge that they consider frivolous. They don't like the challenge. Well, here's a heads up. I don't think that just because you don't like what I'm challenging means that it's frivolous. Words are supposed to have meaning. And so I did define the word yesterday. Now, not every definition of frivolous has the added bonus of, like I think it was point number 2, that it does not controvert one of the points made. But you could see the 2 constants, as I mentioned, is it has to lack merit and it has to be brought in bad faith. Now, if they're going to argue that my argument is a frivolous argument, that and again, let me repeat this. Their argument is, if I'm physically in Arizona, the laws apply and create obligations and give them jurisdiction. I asked them for the proof, and they admit it is an assumption. So my final position there is, my argument is that the argument that their claim lacks evidence. Now, if they're going to claim that that's frivolous, they have to show it has no merit and that it was brought in bad faith. Well, are the facts wrong? No. The law in question requires them, they have to have the proof. Due process requires they have to have proof. They admittedly don't have it. So my conclusion follows directly from the facts and a solid legal principle. So it's not frivolous. They're the ones that are raising a frivolous argument. It has no merit, and it is certainly in bad faith because they're lying. So like I put in the video, look at the lawyers, and this is applied also to pro per. We're held to the same standard, I would imagine, ethically too, which I don't have a problem with. 3.1, they may not argue without facts and law. The argument must be based on facts and law. 3.3 is, and now this may not be the same in every bar association, but it's the American Bar Association, and pretty much every bar association rules that I've looked at mimic the same ethical rules. So 3.1 and 3.3 are going to be fairly standard. It may just be a difference in the number, but not in the actual substance of the rule. So rule 3.3 is really, really important for us. And I'm not saying this because if you say, oh, rule 3.3, he's lying. He's violated the ethical rule for candor towards the tribunal, which does apply to administrative proceedings. They're not going to do anything, but we have to make the objection and make the point. Especially if you're in front of a jury. The jury might be interested in that. They're lying to you. If they deliberately misstate the law or deliberately misstate the facts or deliberately make an argument that they know or are reckless in not knowing is false. So to claim it is a frivolous argument is itself a frivolous argument and a violation of the ethical Call them on it. That's what we need to do. Call them on it. So I want to examine a little bit more about arguments, but I do have some calls. So we'll get to them. I'm hoping this isn't St. Clair Shores, but we shall see. We have a new caller. It's area code 248. You're live on the No State Project. What's your name? Where are you calling from?
Hey, Mark. My name is Rick. I'm actually in Waterford, Michigan, not too far from St. Clair Shores.
Well, I'm glad it's not St. Clair Shores. It's not about St. Clair Shores, is it?
No, it's about my personal situation. I'm in Oakland County. I don't know if you know Oakland County at all, but I'm currently on felony probation at the moment.
Oh,
I'm 41 years old. I took a plea on my case back in January of 2018. Well, I was arrested on January 22nd of 2018, but I ended up, pleading out because I had such a high bond. It was $250,000 cash only.
What the hell did they accuse you of?
Well, it was a situation. My mother, I was arrested at my house. My mother had made a false allegation that I had assaulted her, and that I had a gun on me. So I got arrested for domestic violence and felonious assault, which none of it even happened. So
why would she do that? I mean, why would she do that though?
Well, she's been going through a lot of mental health issues for, a lot of her life, but it's been really bad the last few years. So I still don't really know why, specifically why she did that to me. It was 3 a.m. I was asleep. I woke up around 2:30 in the morning. I heard some noises, and my garage door was open, and the kitchen door going out to the garage was open, and I opened the door and to see what was going on, and I heard some loud yelling. I immediately got frightened, so I closed the screen door and stepped back, and then the people outside identified themselves as police and to come outside, which I did. I mean, there was a police officer hiding behind my vehicle that was on my driveway. As I came out, he had a gun pointed at me. There was an officer to the right side of my house. As I came around the corner, he had a gun pointed at me. And then once I was coming out of the garage, I could see across the small street to my neighbor's driveway, and there was an officer standing there with a rifle pointed at me. So,
wow.
There was guns pointed, but not by me. I've been a gun owner, for a lot of my life. I'm 41. I was a concealed pistol holder since 2004. Never had any issues with guns, and I never pointed a gun at anybody. But so they held me on a $250,000. Well, I was told I was getting arrested. The officer that arrested me, the sergeant, I didn't recognize him because it was in the dark of night, but it's a sergeant that I know. As a matter of fact, I took his concealed pistol license course back in 2004. So it's somebody that I know. We know each other. We're not friends, but, we know each other when we see each other outside. He knows who I am, and I know who he is. But he had, eventually told me that I was being arrested for domestic violence. Never was read any Miranda rights.
Did they question you?
Police station.
Did they question you?
At the scene, no. At my house, they did not.
Did they question you?
As soon as at the police station, I said, Mike, what are you arresting? Why are you arresting me for domestic violence? I didn't do anything. I've never assaulted anybody. He just said, don't, hold on. And he was typing into a computer for like 10 or so minutes. And then, I said, I didn't do anything, Mike. You know me. I said at the time, I go, we're friends. And he goes, I'm not your friend, Rick. I go, okay, well then let me, call my uncle to pick me up. He goes, it doesn't work that way. You're going, I have to take you to the Oakland County Jail. And he said, do you want to talk to me? Tell me what happened. I said, not if you're taking me to jail. I'm not going to talk to you. That's the bottom line. You're telling me you're taking me to jail and that's it? He said, yeah. And I go, well, there's nothing to talk about, right? So I was taken to the county jail. I mean, granted, I've got no prior criminal history at all whatsoever. No juvenile history. I haven't even had a driving ticket in over 2 years. And that's like my only one since I was a teenager.
Wow. Well, I will
going 5 miles an hour over.
Well, I will point out that the Miranda warning is really not even applicable if you weren't answering his questions. So if you started answering his questions and talking and he did Mirandize you, well, then you would be able to exclude, you should be able to exclude the statements. But since you're not sitting there answering questions, you didn't do it at the house. And Miranda, because I've had sometimes when people have called the show and they're all pissed off saying, well, they didn't even read me my rights. And I said, well, okay, did you answer their questions? Did they interrogate you? Well, no. Okay.
So it's irrelevant, right?
It's
it's just something I threw in there.
Well, yeah, I'm glad and we can explore that and explain to people, so people who may not be aware of that. The bottom line, whether they read you your rights or not, every one of us, that doesn't matter what the situation is. We should always say the same damn thing. One time on advice of counsel, I am not answering questions, and you keep your mouth shut. If you have to say anything, which you shouldn't, you could do like what Mike Ehrmantraut did in Better Call Saul and just say lawyer. So they'd ask him a question, he would go lawyer.
Can I throw one thing on there? I hate to mention other people's YouTube, but can I mention another attorney's YouTube where he talks about that? He's got a couple of quick videos.
Yeah, that's no problem.
His name's Dale Carson. Dale Carson out of Florida. So if you type in Dale Carson in YouTube, attorney, he's out of Florida. He's been, he's an attorney, but he was a former Jacksonville deputy, and his father was sheriff down there. He was a FBI agent for many years, but he's got a video on about don't talk to the police. Don't ever talk to the police.
Yeah.
Just so your viewers know, there's another video. There's a lot of videos out there about not talking to the police.
Sure.
At all. I mean, they're not anybody's friend.
There are cops in videos that are advising people. I guess they're telling people, do not ever talk to the police. Yeah, they've got a job to do. Yeah, but they're not going to accomplish. They should not be accomplishing their job or getting their job done because you and I are offering statements and testimony. Yeah, keep your mouth shut.
Right.
And there was one by someone, a lawyer on the East Coast. It's less than an hour long. He does it. It's probably the most common or famous ones for this. He is a law professor, as far as I remember. And so if you were to type lawyer, never talk to the police, he goes through like 8 different scenarios, which covers like everything on whether you're guilty, you're innocent, he covers it all and explains why, especially if you are innocent, never answer police officers' questions. What I do? See, because real quick, because one of the things he goes through is we have no idea what other witnesses and what other people have already told these police. So whatever we say could be completely it could be right there and be the absolute verifiable truth. But if you contradict what somebody else says, if somebody else in the investigation has lied, you're now on the hook. And now they could arrest you. So keep your mouth shut. Always.
Yeah, and I think and I know that video I think you're talking about. It's he's that professor. I think he was a friend of Justice Scalia and another justice. I think he's got that book that he's a small little book that he gives out or sells or whatever, talking about that. And he'll even say, I mean, unlike most of us, if you've got a family member that's a judge or a DA or a police officer or a sergeant, they tell their friends and family that, like you said, they'll tell people they know, don't ever talk to the police.
Yep.
Don't do it. There's no need.
That is probably some of the most sound legal advice that we can get and adhere to. You keep your mouth shut. There's no way you're talking your way out of a ticket. If they're insistent on giving you a ticket, let's just traffic, you're going to get the ticket. Deal with it in court when there isn't a chance he's going to pull his gun and shoot you or drop a bag of, something in your car. As we've seen recently in the last couple of years, there's been quite a few police officers. Oh, my gosh, Rick, on their own body cam.
The guy in Florida,
evidence.
Right? He's got 16 felony counts. Zachary, his name's Zach something. I forget his last name.
Well, maybe somebody can on the chat can look up Zachary, the police officer in Florida, because I definitely like to get that in the show notes and keep repeating it. It's just like Jeffrey Epstein. Just keep repeating it so people don't forget about it. So if somebody can get us that would be great. Well, I'm getting lined up with calls, so let's get to why you called, because I mean that's great information. I'm glad we talked about it, but we got to move on.
One quick question I had, because this retains to my preliminary hearing, when after I got video arraigned back last year when this happened. I got video arraigned because I was in the jail. They gave me a $250,000 cash only bond, but like I said, when I had my pre-trial, they took me from the county jail to the district court. Now I ended up having 3 preliminary hearings. But one of my questions is this, on my second preliminary hearing, when I came into the courtroom, there was nobody in there because it's a small district court. It was just the judge, my attorney, somebody from the prosecutor's office, and like 1 or 2 law, clerks in there. But when I had come in, the judge said to me, he said, Judge Todd Fox out of 51st District Court in Waterford. He said, Mr. Salapal, me, your attorney, and the prosecutor have been talking about your case for the last 30 minutes, and we need more time, or they need more time. So we're gonna postpone this preliminary hearing once again. So my question is, I know you mentioned in your other videos about ex parte communication. Is something like that in Michigan considered ex parte? Since I wasn't in the courtroom and the hearing had not yet begun. Now, I thought that judges are not supposed to talk to prosecutors and even defense lawyers about a defendant's case. Wouldn't that fall under ex parte or no?
Well, ex parte, when they're talking about ex parte communication, is when, for example, the judge talks to one party without the other party being present. But you told me that it was the judge, the prosecution, and your attorney. So the 2 parties were present. Mm-hmm. Whether you were there is not material to a charge of because it was an ex parte communication. Now, if your attorney is not relating everything to you, if there may be an issue of ineffective counsel, that's a different issue. But ex parte, no, that's not what it is.
Okay. Yeah, well, I definitely had, misrepresentation of counsel. I ended up pleading out. I shouldn't have, but I mean, obviously I did it because, he had told me that, you could sit in jail for up to a year and then still go to prison for up to 6 years anyway.
Yeah, well, the thing is, I'm not saying the charges don't warrant a bail. It's just $250,000 sounds, 10 times, easily 10 times for a domestic dispute. Even if all the facts are there that you did it, I'm just saying for a matter of procedure, it sounds like it's about 10 times what it should have been. And let me ask you, was there actually a preliminary hearing? Did your lawyer actually do a prelim, or did you plea out before any of that was done?
I ended up pleading on the third preliminary exam because of what he told me. I thought I was going home that day because the thing of it is my mother never pressed charges. There was no assault. She wasn't coming to court. That's essentially why there was 3 prelims. On the second preliminary exam, she wasn't there. The police weren't there. They didn't show up. I think that's why they ended up bumping it out to try to get witnesses there. Now, on my third preliminary exam, I thought I was going home, and my attorney had told me the day before that I would be going home because there's no witnesses. So I ended up pleading on the third one. So yeah, essentially I didn't have the preliminary exam to bind it over to circuit. I ended up pleading because of what he told me. He said, you're getting a one-time and a one-time only offer by the DA, which is, that never happens. Like one time only. Even I'm finding out now, even people that end up going through trial, they're offered several.
Well, sure. This is a lawyer who just wants to take the money and go. Thing is, there should have been, and I don't have the time to get into it right now, maybe on another call, because I got a full boat of calls. It just seems that if there was a history of mental, at least a recent history of mental issues, that's something that should have, been in, for a prelim and possibly to at least knock it down to where it wasn't a felony. If you're going to make a deal, I mean, that's getting some leverage on them. But it
should be. She's been diagnosed by her mental health physicians as schizoaffective, which is schizophrenia mixed with very severe manic depression. And that's her mental health diagnosis.
You see
that wasn't even, it didn't even come out.
Yeah, that your lawyer
he screwed me over.
Yeah, if she had if that was the diagnosis, and you have a licensed, qualified psychologist or psychiatrist that made that diagnosis, and if she was on medication, whatever, if there is that diagnosis, that should have been taken into account, and at the least you should have been able to get it knocked down to a misdemeanor. So that sounds like sounds like a lawyer who
I wish I could somehow go back. Some people are telling me that I can somehow take this back. I did put my appeal in once I was released from jail 100 days later. I was sentenced, and then the judge told me you have 100 days to serve. So by the time I got out of jail, I did put that letter in of appeal to appeal the case. And I was appointed a court-appointed attorney at that point because I was, I'd lost my business. I had lost a lot of money in that time. Somebody's telling me that I can file like a 6,500 motion, 6.500 in Michigan, to maybe go back and do this over. I mean, and not to rush to, I'm currently facing a violation of my probation right now. They gave me 3 years of probation. I have a hearing on October 24th where I'm going in for violation of probation. I could potentially go to prison for up to 3 years now, or X amount of county jail time. My violation of probation is that I didn't complete their domestic violence course. Now, I did attend 52 sessions of it, but it's not considered complete. Oh, and I paid $1,000 because it's $25 a session. It's not considered complete because of all the things they want you to write down. Give 5 personal examples of sexual abuse. Give 5 personal examples of physical abuse. Give 5 personal examples of financial abuse. And these abuses and all the things that are in that book that they want you to write down, or you're not considered to be complete. Now I'm facing a violation of probation because, they've let me out of the course now, saying, well, if you're not going to write all that down, you're done with the course, and we're going to tell probation that you refused to complete it. So I got a violation of probation hearing next month where I think I'm going to prison from what some of the attorneys that I talked to are telling me.
Well, from what you're relating, it sounds pretty damn bad. I would have to look up this particular motion, but I will tell you, whatever legal remedy may be available to you to get this overturned, and let's just say ineffective counsel, jurisdiction, and and that the facts just, they didn't have all the facts, or they neglected to collect the facts. Whatever it happens to be, it's going to be extremely difficult to get that overturned. So we'll have to cover. Yeah, let me look into that, and we'll have to cover this on another show.
Can I email you?
Sure.
What's your email address?
It's markstevens@mail.com.
Just so Mark, MARC Stevens @mail.com.
That's it.
Okay, I'll send you an email with a little bit more detail, and maybe we can communicate that way instead of taking up so much phone time for everybody, because my case is just
a mess.
So involved now.
This is pretty serious. So get me on the email.
I don't want to be fair to everybody else.
All right,
but that's the gist of it.
Well, it's bad, but I'm glad you called, and we'll cover more of this, and off air and on another show.
Okay, I appreciate what you're doing, and I appreciate what people like yourself are doing on YouTube. It's a great help.
Oh, I'm glad I'm able to help. Thank you. We're going to move on. He's been on the show before. He's actually from Canada. He is the first one that was reported that when he asked a police officer on the stand to support his claim about jurisdiction, about what facts he relied on to support the claim that just because he was physically in Canada that the laws applied, he got an answer. He was able to get an answer from the police witness. So welcome back to the show, Jermaine.
Oh, what? I'm on the show?
Yeah, I was just trying to be professional and I was trying to.
I was just chilling. Yeah, I was just chilling on that, listening to the show, and then what the hell?
I was trying to give you a proper introduction there. Well, it's been a bad week for me, but there are people that have it worse. But hey, this is like 4 shows in a row without my having to travel. So I'm glad to be back on a regular schedule.
Yeah, that's great, Mark. I know it's tough out there, man. I'm hearing some of the stories that are coming across your show, and really it just breaks my heart that this stuff goes on.
It's
but yeah, I'm just still trying to follow. Oh, sorry, you're breaking up a bit. Go ahead, Mark.
I think that's your end, but when you hear things like what happened to Rick, I mean, come on, it seems like a no-brainer. First of all, $250,000, that is exceptional. I mean, I could see if the guy had, was a rape or a murder, $250,000 to $1 million when you're talking about, really serious violent crimes. But here, $250,000, they're not even taking into account the mother's schizophrenia. And to have him plead out before a prelim. Let me go on record again. If you're charged with a felony complaint and you have the opportunity for a preliminary hearing, don't waive it. Get that cop or tax agent on the stand. Start, question him. Have the prosecution jump out of their chair saying that they're not qualified to testify, so that you can use it on, to your advantage. Hopefully, if they're going to continue charging you, never waive the prelim.
Yeah, that's exactly it. And they will, like when I cross-examined the police officers, they blatantly told me that they were contracted. They're just getting paid to do what they do. So, but I wanted to go back to, I think, episode 28. You were talking to somebody from Alberta. I don't remember. I think his name is Matt.
That might be right. I got
Matt or
Matthew.
Brad or something.
Yes, Matthew.
Yeah, just because I heard him talking, I think he was a little bit confused about how to get discovery and all that.
Yeah, we discussed that. And yeah, you mentioned on Skype, so it's a disclosure request.
Yeah, I think they call it disclosure request out here. So if you're still looking to get that done, or even if you can get into the chat room, I might be able to guide him through, because I went through that gauntlet, so I know pretty good.
I will, for Matthew, if you're listening, and I hope y'all, whether live or on the podcast, they recorded the video there, contact me on Skype at Frank Rizzo 3. I could put you into the main chat, and you can get in touch with Jermaine.
So one other thing, actually, I've got a couple of demands for money again from these people.
Really? They haven't left you alone yet?
Yeah. They just won't leave me alone, Mark. I'm telling you, man, it's crazy.
These people.
So one of them is from the Canadian Revenue Agency, whatever, blah, 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 subsection. They don't tell me how much they're demanding, but they're demanding they're demanding payments of, it says that that tax refunds will be applied to the money that I owe them, the debt that I owe them. And then the other one was similar to your California guy. I set up a business, and now they're requesting taxes on that business for the year it was in operation. And also they're requesting, check this out. So they're requesting that I pay $146 for a license renewal, even though I didn't renew the license and the business is no longer in operation. Yeah, they're still demanding $146 for renewal of license, whether or not I'll be using the license or not.
So there's no more business. You didn't get, so there's no reason for renewal, but they still want it anyway.
Yeah, that's right. Because I guess the renewal is like a subscription fee, which I was not aware of. They didn't tell me that. So I guess it automatically renews yearly. And because basically I didn't allow it to go through, obviously, they're still demanding that I pay that $146.
Is there a process that they have that you're supposed to go through to cancel a subscription because you're not doing business as that entity anymore?
Well, see, that's the thing. I got to call them because I just received this on August 8th, 2019. I know it's a far back, but actually I was not here. So when I got back to Calgary, checked my mail and it was there. But I'm assuming that probably there was some way to cancel it. But like I said, I didn't even know it was a subscription.
And they're not going to care about that. Right? There's got to be a way to cancel
Yeah, exactly.
it. You know, I say, look, I didn't know it was a subscription. That's my way of canceling it. I didn't pay it. It's not a business anymore. Do you have any evidence to show that I'm still in business and required to do this?
And then the other one is the fact that they're actually demanding that I pay taxes on the revenue of that business. So that's a whole other thing. I'm going to have to go through this whole process again. I'll have to reorder the motions, and this time it's going to be at the revenue agency.
Well, you're not in court yet, right?
No, it's not in court, but that's usually where it ends up, right?
Well,
if you don't respond to their letters.
Well, you want to make sure. Look, the way I always do it, and yes, we've had success with the CRA. I used to work a lot with the CRA. I just haven't done at all this year. You start by, and I know it's very difficult to get through to the CRA. I understand, but you want to do just like what we do here, and I've done it over there. You want to make sure you get them to confirm what their foundational argument is against you, that you're physically in Canada, the laws apply. You want the evidence, and you want to make sure that you write down what their answers are and the day and times that you spoke to them, and then use that as a basis for an abatement. And then if they don't, well, then there's remedy. You know, there are remedies you could pursue, administrative, before the matter lands up in court.
So, do you suggest I should call them first, or just write it?
I like to call them first. Because I want my position.
Yeah, I think so too.
I want my position to be based on facts.
Sorry, go ahead.
I want my position to always be based on verifiable facts. So when I write the letter as a follow-up to ask for my abatement, I can do it based on facts. So now if they come back like I started the show, now if they come back and they say, this is your frivolous argument, then I go, well, what the hell are you disagreeing? Show what part of this is wrong. Just identify the parts that are wrong, that I have, and that I've made an error. They won't be able to do that. The best here that they can say is, well, agent so-and-so doesn't speak for the CRA. Well, that's why I said if you disagree, that's why I put in the letter. If you disagree, please provide the facts and a direct contact number for an agent that I can work with to resolve this. So we always look, I could be wrong. I could be wrong. And maybe that agent can't speak for the agency. I didn't know that. They spoke as if they could. That's why I always ask them, do you have the authority to abate this? And when they say yes, all right, then we move ahead. So if they're saying that they can't speak for they can't, well, then now, okay, well, now we've got an issue of bad faith where they misled me into thinking that they could. But yeah, I would definitely definitely call them.
Give them a call. Okay, yeah. Well, yeah, thanks, Mark. I was shocked that actually you picked up my call because I'm sure everybody else is waiting. So I just, you know what, I'll email you as well, like the previous caller, because I'll probably need, to follow. Well, we'll see. I'll call them first, and then we'll see what they say, and then we'll go from there.
Yeah, and if you want me to help with that call, just let me know.
Yeah, and for sure. And you know what? Discord or whatever. So I lost contact with Kevin and all them. So if he's still there, I don't know. Yeah, I need the chat room.
Yeah, well, contact me off air, and we discuss things. We communicated on Skype today. So and I know I need to spend more time on Discord. I am planning to do that for the role playing. I'm doing the best I can, guys. But yeah, contact me off air, and we'll set something up about making a call.
Okay, Mark. Once again, appreciate it. Take care.
No problem. Appreciate the call. Jermaine in Alberta. Yeah, I actually acted as a McKenzie friend there, helping out. And for those who want to turn around, and this is all documented on the show, and Jermaine has called a number of times. Jermaine, unfortunately, did some time, but did wind up getting most of the charges thrown out. So for those who want to say, well, there's no actual proof that Marc Stevens has ever helped anybody, you just got to go to markstevens.net and look at the success stories, and you can go through the archives of the show. Is it the best archived website on the no, but the proof is there. The proof is there if you're willing to look at it. And Jermaine is just one of many. We've got, let's see. Oh, this is always interesting. We've got Lucas from Philadelphia, Mississippi. Welcome back. Wow, you got a lot of background noise, my friend.
How you doing, Mark?
I'm doing well. How are you?
Can you hear me?
Yeah, I can hear you. It's pretty loud. You got good news for us today?
Oh. Well, it's somewhat good news, but it's more hilarious than good.
I can deal with hilarious. Okay.
All right. Well, I get in there, I have to sit there and wait till almost the end because they knew I was just the full something. And I had 2 more people after me, but of course they was going to have to wait anyway because they was in orange and white. Well, I get up there. He asked me, do you have a tag on the truck? I said, no. Did you have a tag on the truck? I told the prosecutor, no. He looked at me funny. He said, well, I don't have no choice but to find you. I said, hold up. Before you say you find me guilty, I want to see your proof that says I have to have a tag. Oh, did he back up? He pulled a Homer Simpson. We're going to have to wait for the officer to get here. And they sent me off to the 16th.
Oh, so so you're saying the police officer does have such proof?
Well, I'm going to get them on that whenever the next court comes around, because now you postpone me. You're the DA, you're prosecuting the case. You're supposed to have the evidence. The officer, I don't believe, has the evidence. And that's when I'm going to go, what is your firsthand knowledge of this? Now that I'll be able to ask the officer, because she was out for medical leave and was supposed to have been back. Let's see, that was on Wednesday. She was supposed to come back to work Friday. And so she wasn't able to be there because she was out on medical leave. But she's back at work now, and they got a couple things going on. So it's going to be the 16th of next month before my court's up again.
Okay. Well, did you confront the prosecutor about the lack of discovery?
No, sir, I did not.
You had him
through about discovery.
Yeah, you had him on the run. You want to remember, everybody, you're in a situation like that. Lucas had him on the run. He had him bailing and trying to scapegoat the cop. That's not a valid answer. When you're there at a pretrial type of a conference, he doesn't have to give you the physical facts, but he has to tell you. That's what discovery and disclosure is about. He has to tell you what they plan on, so if it's a murder trial, well, what's the murder weapon? Well, we're not going to tell you to the day of trial. That's not how a fair trial works. So the prosecutor here doesn't have to give you the gun. He doesn't have to show you the gun, but he has to at least tell you what he's planning on bringing so that you can adequately prepare for a defense. So here, the prosecutor you pushed him into a corner. You could have really brought the hammer down, so to speak, by bringing up that it's discovery. Well, what facts are you planning on bringing out? What facts is the police officer going to testify to?
Okay, well, I missed that point, but I did ask him for what is your proof? Because I'm not the one that has to show proof. They are.
Right.
You know, what valid facts do you have that, and nothing was given to me, and he couldn't say nothing, so undoubtedly he don't have anything.
Well,
You know, he's saying that the officer's going to be the one. Well, whenever we dismiss the officer at the next hearing, it's back to square one. You know, okay, well, this is what I asked for last time. You said she had it. Now she's done got dismissed. So now what's your facts again?
well, I would file a motion to dismiss for prosecutorial misconduct and also the motion in limine, because they're both the argument is basically the same, in that the accusation against the prosecutor is the same, that they are proceeding nominally without evidence and without a qualified witness. And I would make that a point before they even try to put the police officer on a stand. That I would objection. The prosecution, as I laid out in my motion, has failed to provide discoverable information and material. They're not telling me what facts the police officer is going to be testifying to. They're not presenting any proof that the witness has personal knowledge of the matters they're testifying to. And these are discoverable. This is something that the prosecution is supposed to give you before the trial. Again, he doesn't have to give you the actual documents, but no, he has to give you the documents, but he has to at least tell you who the witness is, the personal knowledge, the proof that he has to show that the witness has personal knowledge. They have to tell you what the main facts that they're going to be testifying to. That's this, and to not give you that is to hinder your ability to effectively defend yourself. So you can't have a fair trial if you can't have the opportunity to get the evidence being used against you, so that you can come up with an effective defense.
Well, I already know what they're going to say on as far as, you know, my evidence. The officer gave me the evidence the day that I got the ticket. That's all the evidence that I need.
What specific? So and now great. Let them say that at the beginning, before the trial, before they put the cop on the stand. What specifically did he give me that proves the foundational claim that just because I'm physically in Mississippi that the laws apply? What specific facts prove that that's true? Because you could tell, I'll plead guilty.
Yeah,
Y'all, I'll plead guilty right now. I ain't got to waste y'all's time. We don't have to. We can rock and roll on them on a plea of guilty, and we can avoid the trial. So definitely hold that prosecutor's feet to the fire. Holy crap. We got a lot of background noise there, but
I'm sorry. I'm sorry about that.
Oh, that's okay. We're pretty much out of time for the show anyway. Let me see if we got, yeah. So, well, it sounds like you did a decent job of confronting the prosecutor. Just make sure you prep so that when you go in on the 16th, you do not take don't let the focus come off of the prosecutor's burden of proof. Okay, keep it right on their shoulders where it belongs.
So yes, sir. I'm gonna keep it there. They can't prove. If they ask me for anything of proof, I'm gonna bring up again. By law, I am innocent until proven guilty. You show the proof. The burden's not on me. It is on you.
Yeah,
to prove to me.
Yeah, you need to bring out that the prosecution is not meeting the burden. They've been confronted several times before. I've asked for the disclosure. They're not giving it to me. Okay.
Correct.
All right. Great. I gotta let you go.
I'm gonna keep fighting on.
Yeah. Well, great. And if you have any other questions or concerns, you want to do some role playing, definitely get me earlier on the show. And we can cover, we can do a mock trial to kind of gauge where you are and what you need to do to be able to go in there and more, better prepared.
Yes, sir. I'll sure do it.
Appreciate the call. My name's Marc Stevens. This has been the No State Project for what day? It's the 28th. It's Saturday, the 28th of September, and we're covering some pretty good ground there. And just when you see these arguments that the cop or prosecutor is making, we cannot accept them at face value. We can't accept that the prosecution is right just because that's the way it's always done. I don't want to be that guy to always say it's that logical fallacy. It's not. Oh, it's straw man. And but popularity or tradition doesn't make an argument true. Saying that if you challenge that, it'll piss off the judge. That's not a valid reason. That does not negate the argument. That does not contradict the facts. Remember, we're talking about a system that at its very foundation is criminal. Again, it's not that the accountants and the average, that they're committing overt crimes against people every single day. No, well, the cops, yeah. Prosecutors, yeah. Judges. But it's a criminal organization nonetheless. And all the things that I explain in Government and Diet as to why they're acting the way that they do. Well, because they can. And why can they do that? Because they have a prison system. Because people still buy into the notion or act as if they do, that they have a moral right to be immoral, a moral right to be unethical. That if you and I were to act in the same manner, everybody would unanimously declare us to be criminals. And they're right. But for some reason, they give a pass to these people. That's the system. We're dealing with a system that is immoral. And yeah, we use due process and things like this to show the contradictions. And somebody wants to point out, like with one of the cases in California, where a judge did come out and say, well, if the Constitution doesn't apply, then you don't have any due process rights. You can't complain about due process. Well, why don't you? And I can accept that. But the judge wasn't consistent. Because if you accept that that is true, that's the basis of the prosecution's argument on personal jurisdiction. So if he doesn't have any, if the Constitution doesn't apply and you have no due process protections, then guess what? The court can't possibly acquire subject matter and personal jurisdiction. So at least be logically consistent. Plus, it doesn't matter because the judge takes an oath to preserve, protect, and defend the Constitution. The due process is his obligation, no matter who is in the court. This is you have to look at things. We have to look at things logically. We want more context. Is it consistent? And these arguments that these prosecutors and tax agents and police officers, the arguments that they're using against us, while popular, are not valid. The fact that they will just put you in prison and ignore is not a statement as to whether the argument is valid or not. It has to do with how criminal that they are. So you have to examine the arguments with a clean slate. Don't take any preconceived notions. Don't go into it just because you're an anarchist. Look at the facts and examine the argument for its own merit. It doesn't matter what the courts have said. It doesn't matter what some lawyer said. Does the argument hold water, yes or no? Is it logical? Is it based on facts? That is what's important. Not whether a judge accepted it. Well, yeah, you want the judge to accept it if your life is on the line, but that's not a determining factor as to whether the argument is valid or not. So, appreciate everyone tuning into the big show today. I will be live Wednesday, of course. We're on a regular schedule now. So whoever I may have missed today, just hit me up on the Wednesday broadcast because I will be live. I appreciate everyone with the continued support of the show. There we go. The continued support of the show. If you want to be able to help support the show, and it is appreciated, you can do so at markstevens.sells.com. That's SELZ. markstevens.sells.com, and always markstevens.net. And so till we are live again on Wednesday, salud.